Yes.
May it please,
Item number 1.
may it please, my lords, with your lordship's permission, if your lordship will allow me to produce a communication letter dated 10th of June 2026, my lord. It's a small letter. Along with it, there's an attachment of a meeting notice.
One second. Yes, Mr. Malhotra.
Yes, Your Worship, as per this, it appears that the meeting is scheduled to be held on 16th to finalize the feasibility. I mean, Your Worship, that means we can wait a week.
We can wait only. But it is taking very long.
In the secretary level, I think it's all agreed, no? The district level, what's happening?
The district.
I have heard that even the revenue minister had gone and that he had approved.
He was present for the second verification
And
himself
he had
as well.
approved.
Yes, Mana.
That CM is also in favor.
Yes,
And what
Mana.
is happening?
This meeting will finalize this whole situation as per the letter, Mana.
Is it with respect to the site at the existing which place? The printing and stationery department site. That's the one. And they have to also take a call whether the printing and stationery department could be housed in the district court complex running from today,
Yes, Mana.
running as on date. Is that correct?
Yes, Mana.
And there's some issue of quarters.
Let them decide then. Mr. Samuel Swenso, Learned Additional Advocate General, has produced for the inspection of the court a communication made by the Assistant Commissioner Revenue, Lunglei District, Lunglei, to the Additional Advocate General, Government of Mizoram, intimating that the matter for land pooling, and selection of site for the district court complex has been treated with utmost priority, and a meeting of the District Land Pooling Authority has been scheduled on 16/6/2026. First up, the composition of the committee which is to decide finally has also been communicated. First up, there is a meeting notice dated 10th of June 2016 intimating all the members of the committee to be present, including the special invitee, namely the District and Sessions Judge, accompanied by her officials. Let this communication be kept on record. In view of the aforesaid, we are adjourning the matter. This court is adjourning this matter with the hope and trust that the issue shall be finalized as early as possible. List this matter on. We give after 3 weeks. After 3 weeks. 2 weeks. 3 weeks, okay? They will decide. 3 weeks.
15 July.
Oblige, my lord.
Item number 2.
In compliance to the order dated 13/5/2026, my lord, we have submitted an affidavit yesterday, my lord, showing the overall progress.
Now we were interested not in the progress of the building
Yes,
presently, We were interested that it should not obstruct the passage.
At page number 8, my lord. The status of construction.
Mr. Malhotra,
Yes, Your Worship.
is the information correct?
I spoke to the district judge, and Your Worship, yes, he said they are not facing any problem as on date.
The stay orders also would be vacated. The stay also would be vacated. The order dated 21/8.
After that, there's a 24th and order in the IA.
This is 21/8. IA is where?
You see both. This is where the stay order was. So this is where, sorry, you say we are allowed the passage is the building to be constructed.
Right, and we have heard Mr. Swanso, Land Council Swanso. We have heard Swanso. Pursuant to a complaint made by the District Concessions Judge Champai, Judicial District Champai, with respect to ongoing construction of working women hostel at Weng Klang, Champai, which apparently was blocking the only entrance to the current judicial quarters of the judicial officers. The matter was taken up in the PIL. The matter was taken up suo motu on such complaint. During the course of hearing of the matter, it transpired that the building which is being constructed would consume a boxing ring and would also provide obstruction to the ingress and egress from the judicial officers' quarters. As such, initially, a stay order was granted by this court, stopping all constructions till the matter was resolved. In the meantime, an interlocutory application was filed on behalf of the state through the learned Advocate General, who sought modification of the order, modification/rescinding of the order of stay dated 21/8/2025, passed in this case. A scheme for construction of a working women hostel was framed, which would have consumed the building/hall used as a boxing ring, but it would not cause any obstruction in the ingress and egress from the judicial quarters. Based on such statement, permission was granted for continuing with the construction, subject to the condition that such construction would not cause any obstruction in the passage. Today, an affidavit has been pressed. Today, Mr. So-and-so has drawn the attention of this court to the affidavit filed on 11th of June 2026, intimating this court about the status of the construction of the working women hostel and a categorical statement that such construction is within the limited covered area without causing any hindrance in the ingress and egress of the judicial quarters located nearby. First off, in support of the afore noted assertion, photographs also have been annexed with the affidavit. First off, Mr. Malhotra, Learned Counsel for so-and-so, submits that he had a consultation with the
District and Sessions Judge
District and Sessions Judge
Champai.
Champai, who has also affirmed the aforenoted assertion of the state that the construction of the women hostel is only in the covered area without causing any hindrance to the passage from the judicial quarters. In that view of the matter, we do not consider it appropriate now to continue with this PIL. The PIL is thus closed. First, in case of the construction causing any hindrance in the passage, even later, would obligate the Learned Counsel, obligate Mr. Malhotra to bring this to the notice of this court, which bring this to the notice of this court. The interim order thus stands vacated. The PIL stands disposed of.
Obliged, my lords.
Item number 3.
Vague type, some vague type of PIL. Yes, Mr. Samuel.
Yes, my lord.
You have accepted notice on behalf of all the respondents.
I need some more time, my lord.
You need some more time,
To
but
obtain
Madam
instructions.
Counsel, is this PIL not a very vague one for us to pass any order?
We have highlighted.
Environmental degradation, all right,
Yes,
but then
for challenge.
you have not posed any specific, issue before the court. It is something. It's a big area, big boxing ring where you would want to contest the state. And that's not done. This is not the way in which PIL is. We don't call it a focused PIL. Now, suppose you file a PIL tomorrow that there is a lot of corruption everywhere, so that should be removed. Can a court pass an order on such vague contentions? But anyway, since notice has been issued in the first instance, you respond to
Yes, my lord.
we have heard Ms. Rosal. We have heard Ms. Rosal
May I please, Your Lordship?
so.
My senior Zoram Chana has resigned from the post of AMC Legal Counsel, my lord. So, if his name may be struck off, my lord.
Name is not necessary to be struck off, even though he has resigned. Somebody else takes his position. He steps into his shoes. Don't make that statement. Correct. Now, you have to, Mr. Samuel, you have to file the
Yes, my lord.
response affidavit.
Yes, my lord.
As a legal card, those go. Mr. Samuel.
Lordship,
so-and-so.
seeking Lordship indulgence. I'm appearing on behalf of respondent number 7. I like some notice. So I'll be responding PIL.
The AFC,
No, Lordship, Customs Department.
custom.
Customs, yes. Yes, respondent number 7.
Anyway,
immediate
you
party.
respond. You respond. Once notice has been issued, we don't want to close it now. But it is so wide and vague that we possibly can't pass any order in this. That's not the kind of PIL that we entertain normally. Take down. This public interest litigation is for issuance of mandamus to the appropriate authorities for implementation of various environmental laws and the connected rules, regulation, guidelines. First off, the contention of the petitioner is that there have been unlawful disposal of waste material. First off, single-use plastics are still being used. The environmental degradation caused thereby infringes the right to life under Article 21 of the Constitution of India. The prayer made in the writ petition is for a direction to the state for a comprehensive action on environmental degradation, waste management, and infrastructure challenges in in Aizawl. In our estimation, it's the prayers are absolutely vague and general, without focusing on specific areas where there is a breach or the necessity of overseeing the management, overseeing the implementation of the environmental laws, which inheres in it certain safeguards and guidelines. Nonetheless, the petition be responded to by the respondent, be answered to by the respondents. Mr. Samuel, I can't spell the name, Mr. Samuel so-and-so, learned AG, submits that he shall file his response. He shall file the response of the state by the next date. The other respondents also may file their respective response affidavits by the next date, re-notify on so-and-so date.
Obliged.
1st of July.
Is there a PIL vetting committee here?
No.
Therefore such PILs. The issues, you don't think that we are understating or undermining the concern shown by you, but this kind of PIL can't be decided. Now there is a way in which a PIL can be filed.
Yes, my lord.
All right. Normally, in other high courts, there is a vetting committee of the judges who only see the contents of the application, the feasibility of that being taken up in the PIL, and only then it is passed for registration.
Yes, my lord.
A random allegation of degradation, random allegation of non-implementation of laws. I mean, that's something like asking the court to monitor everything under the sun. In which direction would we proceed? Anyway, think about it and later, focus your petition by filing necessary affidavit.
Yes,
Otherwise,
my lord.
this would be dismissed straight away without even asking for a response.
Yes, my
We
lord.
have asked for the response from the state and other respondents only because notice has already been issued, in deference of the earlier order of the court. All right, yes.
Yes, my lord.
Item number 4.
Yeah, yes, sir. Stay. Yeah, explanation taken. Explanation taken.
May I please, Your Lordship, I had undertaken to appear on behalf of the respondents on the last occasions, and I had filed my objection yesterday. But inadvertently, my Lord, I have misplaced the Vakalatnama, which I believe that I had already filed, which I found out this morning, and I just filed my power in respect of all the respondents.
Password kar dein. As prayed for on behalf of the respondents in the IA, the matter is adjourned to next week?
Your Lordship, next to next week, because I have some commitment next week.
2 weeks.
1st of July.
Deeply obliged.
Item number 5.
May I please, Your Lordship?
Yes.
Your Lordship, I appear on behalf of the appellants here in Lordship seeking condonation of delay of 180 days, Your Lordship, in filing the accompanying writ appeal, Your Lordship.
Have you issued notice to the respondents? Is it coming for the first time?
It's coming for the first time, Your Lordship.
There is an application seeking condonation of delay of so-and-so, 180 days in preferring the connected appeal. Let notice be issued to the respondents on steps being taken by the applicant/appellant within a period of 2 weeks, both modes returnable on so-and-so date.
Lordship,
May I please, Your Lordship, there is one small request, Your Lordship. Because there are 961 private respondents, Your Lordship. So let these steps be, my Lordship may kindly grant me the liberty to take steps by way of a newspaper publication, Your Lordship.
Not in the first instance. Not in the first instance. If you find it difficult, then we will see.
Your Lordship, whatever is falling from Your Lordship.
15th of July.
Deeply obliged, Your Lordship.
Item number 6.